Like, as everybody knows in the South, that whether something is partisan and whether it is race related, there's an enormous overlap. So, like, almost anything that you're doing that is partisan is also going to be race related.
Mm-hmm.
So let's say it's true, though, that your intent is just to be partisan. But obviously, the overlap means that you're also, yes, that you're also impacting race. So.
Welcome to Seriously, the podcast that dives into the baffling.
We can't send them to a prison where there's animals, where there's livestock.
The ridiculous.
Like omelets better than sex.
And downright unbelievable political climate in red states like Louisiana.
So we can't go there. There are no vegan jails.
Seriously. Seriously.
Welcome to Seriously. We're your hosts. I'm Michelle.
And I'm Ellie.
Today, we are going to talk about two recent Supreme Court cases that have been argued, Louisiana versus Callais and also Chiles versus Salazar.
Two doozies. Just,
there's
a spoiler alert.
There's a lot.
Yeah.
And we are also going to talk a little bit about the recent elections in Louisiana and what happened with those. I don't know how much we have to say about that, but we'll talk about it because it happened. So before we jump into that, we can talk about our Seriously moments. What you got?
So I was sort of having a hard time coming up with any, and then like a couple of obvious ones came to mind. Number one, which I think this was this week, it might have been last week, but was Pam Bondi testifying to Congress, which was like amazing. I mean, it was really amazing, both because she refused to answer basically any oversight questions. I mean, like that it is literally Congress's role to provide oversight. And, this is an oversight hearing. She's head of the DOJ and a cabinet member. So she not only did refuse, I mean, I don't mean like in the usual way they refuse, which was sort of like roundabout, like, ways of like a non-answer to the question. She was just not answering the questions. And instead of answering any question, then she just insulted the asker.
Yeah.
Like the asker being a senator, like Holman getting the $50,000 in cash that there's
Right.
FBI video of, like, have you reviewed that video? Or like, where is that video? Or did he pay taxes on that money? Like, did you give the money back to him? Did the FBI give the money back
Where
to
is
him?
the money?
Yes. So to everyone who was asking those questions, which included Senator Schiff and Senator Sheldon Whitehouse, who both of whom like are great, and they're both lawyers, and they both know how to question witnesses. Then all she did and said was, well, that's really rich from you, Senator so-and-so, to even be asking that question.
What conversation did you have with Mr. Ballard?
Senator Blumenthal, I cannot believe that you would accuse me of impropriety when you lied about your military service.
I am
you
not
lied.
asking
You
you.
admitted you
I am
lied
not
to be
accusing you
elected
of
a U.S. senator.
impropriety.
Was that true, what the White House press secretary said when she denied Holman took the money? Did he take the money?
Caroline Leavitt is one of the most trustworthy human beings I know.
So
And,
was she?
Senator Schiff,
was she
if
right?
you worked for me, you would have been fired because
excuse
you
me.
were censured
No,
by Congress for lying.
How many of those Treasury SARs did you or Director Patel investigate?
Senator, I'm not sure if you're concerned because you took money, I believe, did you, from Reid Hoffman, one of Epstein's closest confidants, not only once but twice in 2018 and 2024. If that's correct, you voted to shut down the government, and you're sitting here, our law enforcement officers aren't being paid. They're out there working to protect you. I wish you loved Chicago as much as you hate President Trump.
A simple question as to whether or not that a legal rationale for deploying National Guard troops becomes grounds for a personal attack.
She had like a burn book in front of her, and she was just flipping to the tab with that particular senator.
She literally did.
Yeah.
There's been reporting since then from the Daily Beast or something like that, like there were screenshots like at the hearing looking at her notes that it's like, yeah, for each of them, like her canned attack, which Schiff did call her canned attacks at some point, but literally to a person, every single Democratic senator, then not only did she not answer the questions, and like Adam Schiff does a whole litany at the end of all the questions she did not answer,
Yeah.
but she instead then also made like a extremely partisan, possibly baseless, but totally irrelevant regardless,
Yeah.
attack on each of them personally while interrupting them, blah, 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 blah. I mean, I thought it was really astounding.
We haven't seen that kind of insanity since, I think, the Kavanaugh hearing. I mean, that's kind of what it reminded me of.
How
When-
he acted.
Yeah.
Yeah.
Just like completely belligerent.
Yeah, we should possibly put in some of the Matt Damon SNL playing Brett Kavanaugh. Oh,
It is so
fucking
funny.
him chugging water.
Judge Kavanaugh, are you ready to begin?
Oh, hell yeah. Let me tell you this. I'm going to start at an 11. I'm going to take it to about a 15 real quick. First of all, I showed this speech to almost no one. Not my family, not my friends, not even PJ or Tobin or Squee.
It's so good. It's so good. Yeah, this was like, he was like clearly very stressed and just came in like, ooh, we're aggressive, which was also just like, whoa, okay, like what's happening?
Yeah,
Like,
take it down a notch.
Take it down a notch for sure. But like Pam just came in as like, this is just like she was very cool, calm, and collected, and just interrupting everybody with an insult about them to every question they asked. Like, I mean, it's obviously turns like oversight on its head. It makes it completely meaningless. Just the level to which like she and the administration are not taking Congress seriously, even the Senate, is unbelievable.
Yeah.
It was like shocking. It was embarrassing, like for her, but for our process. So that was like a pretty big, seriously. And then the other one, of course, being the Antifa roundtable at the White House.
I don't even know about that.
Oh my God. There was like a fully televised roundtable about Antifa, about discussing the problems of Antifa and like the government's plans to rein in and Antifa and attack Antifa. And it's like Pam, being like, we will use every RICO statute at our disposal, Mr. President. And then like, like Kristi Noem, like, I don't even remember some of the insane shit she said. And just like totally off the wall.
And thank you for hosting today and focusing on Antifa and the terrorists that they are. Let's not make any mistake. These individuals do not just want to threaten our law enforcement officers, threaten our journalists, and the citizens of this country. They want to kill them. Their agenda is to destroy the American people and our way of life, and this president is standing in their way. Recognizing how advanced they are, how sophisticated their networks are, how they've infiltrated our entire country, and we're seeing them play out with their tactics from city to city, and how they have built out their funding mechanisms. And sir, I also want to thank our Treasury Secretary for his work in getting to the bottom of these funding mechanisms and individuals who are perpetuating this violence on our American cities.
But yeah, so I mean, two things about it that are seriously. One is the absurdity of what it seems like that they actually do kind of think that Antifa is like a thing.
Yeah, like an
organization. Yes,
Mm-hmm.
like, which obviously Antifa, it's like, a fringe movement of anarchists.
Yeah.
There's no organizers. There's no organizational structure. There's no headquarters. On Pod Save America, they were talking about how, like they're going to raid Antifa headquarters. Good luck finding those.
Yeah.
But like the administration does seem to like be convinced that this is something that exists. So that's just ridiculous. But then, of course, they're using this as a predicate to say that, like anyone funding them, anyone supporting them. And that's including like George Soros's organizations, including Act Blue, that just, like gathers donations for Democrats. Indivisible, who's organizing the protests today. Today is No King's Day, and has organized protests and just get out the vote effort since like 2016. I mean, like just bizarrely, but strategically trying to loop in just like people who are in the opposition. So while it's ridiculous, it's extremely dangerous because it's basically like the McCarthyism Red Scares, but without any real defined organization, right? So that was very bad. It's considered a very dark dark chapter of our history.
But there was a communist party.
There was a communist party.
Yes.
So now this is just anyone who is like Antifa related and supporting Antifa, associated with Antifa, which is vague and ambiguous, like in reality, and they certainly have no idea what it is. So it's really just the opposition in our country.
Anyone who's opposed to Trump, who's opposed to these policies, I think the statement or another executive order by Trump is like anyone who basically disagrees with Christian values is part of this domestic terrorism.
Yeah, that's right. And so they're trying to like actually label organizations, people, whatever, as domestic terrorists. Then, the outgrowth of this, of course, is like, which also has a local element, is Mike Johnson, then comes out with statements about the upcoming No Kings protests, calling them, the anti-American protests and like the pro-Antifa protests and the pro-Hamas protests. I mean, just just absolutely vilifying millions and millions and millions of people in the United States who are just opposed to all of the gajillion anti-democratic efforts that are underway, which, we would obviously argue, and I think, any logical person could at least understand that that's not anti-American. That's pro-American. It's pro-democracy. You might disagree, but peaceful protest by the opposition is like the entire basis of democratic values. So that's just like a lot of, seriously is in the making.
Well, it's so funny too, because it's a violation of the First Amendment and it's also viewpoint discrimination, which are two themes that we are going to talk about in cases later. The other thing that kind of freaks me out about this, though, Ellie, is so the administration is now just like blowing up boats in international waters and calling it, saying that it's justified because these are terrorist.
They're drugs. They're
drug cartels, but
they are now labeled as like enemy combatants or something like that. Yeah.
But like, connecting them somehow to like terrorism, some sort of threat to the United States, like if terrorists can just be like murdered extrajudiciously in international waters, like what, what's the what?
Well, I mean, they're trying to so two things. I mean, number one of what's supposed to be the limiting principle is that there is no ability under federal law to declare someone or some group a domestic terrorist. That doesn't exist. They're like just saying that all the time and claiming to do that in like executive orders, but there's no legal basis. So that's like, again, just sort of frogs in the boiling pot, just like getting people sort of used to rhetoric and like concepts that actually have no basis in law. And then in the actual Caribbean, I mean, there's no legal basis for what they're doing. And there was a report the last couple of days that I think it's not, they weren't Venezuelans. They was like, I think they were, citizens of Trinidad and Tobago, but like a couple of fishermen that at least those countries claim were murdered by our government under presumably the auspices of, that we thought that they were drug smugglers who we've now labeled as people who can be murdered without like talking to them. Just like the admiral, by the way, I don't know if you heard this is just announced, I think maybe yesterday, in that the person of our military in charge, he just resigned.
It's like, I don't want to fucking just
like, I do not agree with what we are doing.
Well, thank God for that.
Yeah, I mean, it's against international law. It's against, America. It's
against, just kind
it's
of
also
like
provoking a federal, I mean, it's provoking a foreign war. It's provoking war with Venezuela, like whether it's a hot war or, I mean, it's insane. I mean, it goes against all of the Trump principles of being like so isolationist. Like he's very much trying to engage in regime change in Venezuela, like way old, like Republican John Bolton era, like intervening in South America and Latin American countries. But now again, even to a more illegal level,
Yeah.
where you're just killing people in international waters because you think that they're drug smugglers, and maybe they are, maybe they aren't. Also, they're still civilians,
Yeah.
even if they are.
Yeah. And you know what? You can send, like other boats out there to
Interdict them.
Yeah.
Yes.
You can arrest them.
Exactly.
Yeah.
Yeah.
Okay.
Yeah. Lots of insanity.
All right. Well, so my seriously is about John Bolton.
Mm-hmm.
So, former Trump advisor John Bolton has now been criminally indicted for retaining
Not just advisor, UN secretary.
UN secretary. Yeah. I mean, he had occupied various
Yes.
positions in the federal government. So anyway, he's been criminally indicted for retaining and transmitting national defense information. So again, classified documents situation. So the FBI raided his home in August and as part of this investigation. So Pam Bondi, in a statement on this indictment, says no one is above the law.
Yeah, that's her. Yeah, her whole jam.
Yeah. So I'm not saying that what Bolton did here he shouldn't be held accountable for, because it is against the law. But it was also against the law when Trump did it.
Also, I don't know the facts of the Bolton stuff. I mean, whether it's more like the Comey stuff and the Tish James stuff, which is like, is there even a there? No.
This is a little bit more of a there.
There's more of a there.
There's more of a there for sure. So like he was transcribing notes from these documents onto his computer. He was sharing them with family members that were helping him write his book.
Yeah.
And then sending that information over like personal emails. And then those emails were like hacked by Iran. So there's problems. The seriously though is Trump was doing this too.
Well, Trump had documents in a bathroom at Mar-a-Lago.
Which could have been accessible by almost anybody, including Iranians, because they didn't know who the fuck was coming in and out of that goddamn
also
place.
Anyone could, as long as they were willing to like make a big contribution.
Right.
And with Bolton, then I know at least in the end that he got pre-clearance for the book.
Yeah.
So, the way he was handling it in the interim was perhaps reckless.
Right. Yeah.
But it seems to pale in comparison to having like extremely sensitive information in a bathroom at Mar-a-Lago.
Yeah. So
that's it. Pam, every time she says
no
that,
one has above the law.
Like,
shut up.
Seriously,
Fucking
like who are you kidding? How about the Jan 6 folks who you guys exonerated? Like every single one of them.
Actually,
I guess
think
those
a lot
folks
of
are above the law.
It seems like a lot of
Yes, they
people
are.
are above the law.
Yes,
And
in addition to Trump.
yeah.
The people who are not above the law are powerful people who have opposed Trump.
Yes. And Venezuelans.
Yeah, that's right.
Maybe just fishing in international waters. Okay, let's jump into things. I want to start with Louisiana versus Calais.
Okay.
Before you get too drunk.
Yeah, that's probably good.
Okay. All right. I'm gonna give a little background here, and then I'll just let you rip. Okay. So this case is a challenge to Louisiana's most recent congressional map, which created a second majority minority in Louisiana, that means Black, district in the state. So the background to this is that roughly a third of the state's population in Louisiana is Black.
Right.
But Louisiana originally, when they were doing redistricting, drew a map that had only one majority Black district out of the 6 districts that are allotted in this state. So originally, Black voters sued, claiming that this violated Section 2 of the VRA, which prohibits discrimination in voting on the basis of race. And so this is like, if a map dilutes the voting power of people on the basis of race, then that's a violation of Section 2.
Yeah. So the basis of the suit, there's at least 3 different stages of this litigation.
Yeah.
And there's kind of 4 different stages, like in reality, but one involves Alabama. So there's like 3.5 stages of this litigation. So the first part is what Michelle was just talking about, where there's a new census. And so all states then, they have the opportunity, or they're required either way, to redistrict, to figure out, are the district lines like appropriate given what the census is right now.
Yeah.
So the maps that they drew in 2022 only had one minority majority district. So meaning only one district that it's like likely that a Black candidate is going to get elected out of, because it's the only one that has a majority of Black voters. And like the history of Louisiana shows, which is a lot of the evidence in this case, that like the only time that Black voters get elected is when they're coming from majority minority districts. So when the legislature proposes that map, then there's a lawsuit over that. That's the Robinson case. So a federal district court judge, Shelley Dick, she's like been in the middle district for a really long time. She's a good judge. She's liberal, but she's not any kind of crazy liberal. So she agrees with the plaintiffs that the map violates Section 2 of the Voting Rights Act, meaning that it discriminates on the basis of race because it dilutes minority voters. As Michelle said, I am not an expert in this area of law, so I do want to be clear about this, but I do list some of the terminology, like packing and cracking.
Yeah.
If you're packing minority voters into a small area, or you are cracking up various communities into different districts, those are ways that you can dilute the vote. The important thing with this is with Section 2 is that it doesn't require that it's intentional. The legislature doesn't have to be intentionally discriminating on the basis of race. It's just that the effect is, the actual effect is that it is diluting Black votes.
Right.
So, and in order to prove that, you have to be able to show that there's a different map that's reasonable, that would not be discriminating on the basis of race, or not be diluting minority votes. So that's what the district court judge finds, is like, okay, this map is bullshit. Yeah, this map is bullshit. It violates Section 2. Yes, you have to try it again. She didn't give them a lot of time. There were upcoming elections. There was like a lot of like hand wringing and whatever. But then that case goes up on appeal to the Fifth Circuit. It gets affirmed. So meaning that our very conservative Fifth Circuit said, like, we agree the current map violates the Voting Rights Act. Then the state of Louisiana takes it up to the Supreme Court. And the Supreme Court stays that. Like, there's not going to be a new map. Nobody has to do anything because this Alabama case is pending. So that's like Allen versus Milligan, a case that was like very similar to the arguments that are being made now. So this is just 2 years ago. The Supreme Court affirmed that Section 2 Section 2 of the Voting Rights Act is constitutional, meaning that requiring for there to be some sort of race conscious like plan in redistricting, if there has been a violation that was already identified, the voters were being diluted on the basis of race, that's constitutional. So like that happens, and then Louisiana is like, okay, handwriting is on the wall. We need to draw a new map.
Right.
Like clearly we're gonna lose on this. So they draw a new map, and it's the map that's currently in existence in Baton Rouge.
So when Louisiana went back to draw this map to address what the court had said, they didn't really care about the creating another majority minority district in the state, but they felt like they had to. But what they did care about was protecting incumbency for Moses Mike Johnson, the current House Speaker, and Julia Letlow, who was on the Appropriations Committee. So that's kind of important context in how they drew this map, because it's wacky. But anyway, go ahead.
The problem here, I guess, I mean, this is a good point to say. The problem is that if what happens, what it looks like is going to happen, where Section 2 gets either declared unconstitutional now, or like just gutted, the part of the VRA, that like allows for a remedy when there's just like the effect the effect is discriminatory. It doesn't have to be that the intent is. So if you take that away, and then in the context where we already are with the Voting Rights Act, where they've already gotten rid of pre-clearance with Shelby County, so meaning in all of our states in the South that have an absolute history of intentional discrimination, gotten rid of the requirement that new maps be pre-cleared by the Department of Justice to make sure that they're not discriminatory. That's gone, Justice Roberts, Shelby County, like, dude, we're so far from the days of Jim Crow, which,
Yeah.
like,
There's
I don't
not
know,
yet.
last time he was in the South, we're not so far from.
That's right.
Not at all. But that's gone. And then the Supreme Court has explicitly said that if it's partisan gerrymandering, if your purpose is to do stuff like you're saying, like to support incumbents, or if your purpose is to favor Republicans, like if you're a Republican legislature and you want to favor Republican, then they're not going to look at that at all. And like, as everybody knows in the South, that whether something is partisan and whether it is race related, there's an enormous overlap. So like almost anything that you're doing that is partisan is also going to be race related.
Mm-hmm.
So let's say it's true though that your intent is just to be partisan, but obviously the overlap means that you're also, yes, that you're also impacting race. So that's where Section 2 would at least still say, okay, your intent was to be like, reelecting Moses Beck Johnson and Julia Letlow and, trying to, while keeping race in mind, trying to, do what you can to be partisan, basically. But if you get rid of Section 2's ability to remedy effects discrimination,
All bets
there's
are off.
pretty much all bets are off.
Yeah.
So they redraw the maps. Louisiana redraws the maps, 2024, because they think they have to. They think that like that Section 2 is going to hold, and that
Under duress.
Yeah,
I think actually how they argued
under
it.
protest. They say
Under protest. Right.
So they redraw the map. It is challenged basically immediately.
Mm-hmm.
So the first one's called Robinson. The second one's called Callais. The second litigation is a bunch of white voters that say, well, the new map, it takes race into account too much. If race is predominating the map, then that violates the Constitution. That violates the 14th Amendment and the 15th Amendment. So that's what they say, is that race predominated the determination of this map. And so therefore it's unconstitutional under the 14th and 15th Amendment.
But really what they're saying, these white voters, is that by trying to remedy the violation of Section 2 that discriminated against Black voters, you are now discriminating against us.
That's
white
100%
voters.
what they're saying. It's a reverse racism theory. Yes, the Constitution abhors discrimination on the basis of race, right?
Mm-hmm.
Based on the 14th and 15th Amendment. 14th Amendment, of course, being protection, 15th Amendment being voting, like the actual right to vote that came out of the end of the Civil War, which is what the Voting Rights Act is based in. Like it's the mechanism in the 60s that was to operationalize the 14th and 15th Amendment. Now it's being used to say that maybe the remedies that courts and legislatures are using itself violates the 14th and 15th Amendment.
Because white voters.
Yes, because
Crazy.
race cannot, because race, and a lot of that, of course, was very smart tea leaving and opportunistic on their part, because coming out of the Harvard case that Supreme Court decided, we're saying that like can't use race at all in admissions to college admissions. It gutting all of the affirmative action precedent, about remedying past discrimination and like that race can be a factor.
Which is like, is that the case that Roberts said the only way to stop discriminating on the basis of race is to stop discriminating on the basis of race? Yeah.
So, but importantly, that case came out during the same term as Milligan, the same Alabama case. So like the court was like holding these things in their mind at the same time, that, that race conscious redistricting was still constitutional, even if they didn't believe that it was still constitutional in the context of school policies. Again, we're talking about a statute versus a policy, which
Right.
that seems to have gotten lost in this whole
Well,
analysis.
not only a
but-
statute, but also a statute that was the enabling statute to effectuate constitutional amendments. Like,
Yes.
very different.
Yes.
Okay.
Many years later.
Yeah.
Because they weren't being effectuated.
Right.
So the argument being the new map is unconstitutional because race predominated in the analysis. And so therefore it is racially discriminatory. And so those are the Callais plaintiffs, a bunch of white people. So a different federal district court agreed that race did predominate. Therefore, if race predominates, then that means strict scrutiny applies, and it fails strict scrutiny, and there needs to be a new map. And then the Fifth Circuit affirmed that, this new map that violates the Constitution.
Okay. So district courts said
It's different judges.
discriminating against Black voters violates the VRA, and then a new case with the white voters saying that now they're being discriminated against. They're like, "Yep, you're being discriminated against too."
That's
right.
This
is insane.
It is insane, and that's actually part of Louisiana's argument for getting rid of Section 2. But they're not wrong that they're wrong on that, but they're not wrong on the catch-22 sort of thing and how the Supreme Court tests. To some extent, there's always going to be an argument in theory that at one point you considered race too little and at one point you considered it too much. Like a lot of the points in the oral argument from, Justice Jackson, who, let's be honest, is the only Black justice who is supporting Black people on that court, because Justice Thomas is actively trying to dismantle the system that helped Black voters and Black people and women and everybody else to get their civil rights. Like, that is his agenda. Hers is, to try to uphold the system that has given people civil rights. There's a total illogic here, though, that if the violation is that, whether intentional or not, that, voting ability is hurting people on the basis of race, then there needs to be a remedy that's on the basis of, or that at least takes that into consideration. So then that case goes up to the Supreme Court last term, the first version of Callais, which is really just about that. Is this map unconstitutional? The state felt like that they had a compelling interest to comply with Section 2 of the Voting Rights Act and create a new map. Did it go too far? And did race predominate? There was oral argument on that last term. Our state, including Liz Morrell specifically, took the position that race did not predominate, that the map should stand. The bullshit with incumbency and partisan politics played an enormous role in picking that map. And also, as a side note on this, that all this map was under dispute in the federal courts. Then the 2024 elections had
we
to
had an
happen.
election.
Yes.
We've elected someone into that district.
That's correct. Yeah, the district exists. So Cleo Fields has been elected. He's Black member of Congress now in this district. He also was gerrymandered out of another district when he was in Congress before. So this is the Cleo Fields story and gerrymandering. Maybe there will be
so many remedies
about that, because it's about to happen again. He's about to lose his seat again. Yeah. But anyway, so then it's argued before the Supreme Court, and Louisiana defends the map, and then everybody waits for a decision, and then no decision comes. And instead, at the end of the term, the Supreme Court orders that it's going to be re-argued. So that's very, very rare, just to be clear. It's very rare. It happened in Roe, by the way. With Roe, it was argued, and then it was not decided. And then it was very surprisingly ordered for argument again. There was some change on the court. There was a lot that happened. So all of a sudden they say, we're not going to decide it. We wanted you guys to come back next term and argue it again. And then they issue these new questions presented, which is, is it unconstitutional to create majority minority districts. Like essentially is Section 2 of the Voting Rights Act unconstitutional?
Yeah.
Under the 14th Amendment and or the 15th Amendment. So in other words, this case isn't going to decide what is the map for Cleo Fields or Garrett Graves. What is the map in Louisiana? Like, this is going to decide, or is Section 2 constitutional at all? And if so, in what way? And so Louisiana now has switched.
Yeah, that's what I was going to ask you. I was like, well, so now that's the question, Louisiana's like, oh, well, we want to get rid of Section 2 of the Voting Rights Act, so we're not going to defend our map anymore.
That's right.
So, yeah.
So now, Louisiana is arguing that Section 2, so meaning anything that's looking at what the effect is of vote dilution, is unconstitutional.
Mm-hmm.
Kavanaugh's real interested in, because he was really interested in this occurrence in the Milligan case about whether there's a temporal limit, on the VRA. Whether at some point in time, we've just done enough.
Racism.
We've just done enough.
Yeah.
Which is what they said to get rid of Section 5, obviously, with Shelby County. What all litigation under that section is about current conditions. There may be evidence of past discrimination, and or intent, but it's based on current conditions. So no, there's not a temporal, there shouldn't be a temporal limit. You're talking about what's currently happening. So that's Louisiana's position. Get rid of it totally, which, to be clear, would require them to basically overhaul, if not overrule, their precedent from 2 years ago, and also from Jingles 40 years ago that has been successfully applied all of this time. So a lot of precedent overhauling,
which is also, again, not unlike abortion.
No, not at all.
2 years before Dobbs, they had agreed that Louisiana's trap laws were unconstitutional.
And 2 years before that, same in Texas.
Same. Yeah. Which was based on, 40-year precedent. Yeah.
Yes.
Okay. Anyway.
Yes, exactly. Their theory is that Alabama went all in and said that, if there's no intent, then there can't be a violation of the Constitution. And so to the extent that Section 2 allows for remediation where there's not intent, and it's unconstitutional. So the federal government, they were trying very much to distance themselves from that. They're like, that's not what we're saying. We don't know why Alabama argued that. Because which court watchers were really worried at the time that the Supreme Court, of course, it's only 2 years ago. It's not this is with this bullshit court that they were going to go for that. So now they're like, well, that's not what we're saying. That is not what we're saying. What we're saying is that there's no, there's no world, though, in which race conscious redistricting isn't unconstitutional. That the remedy always has to be race neutral. If the court goes with the federal government's plan of this, it'll be a new test that is difficult to apply, but that excludes race as a consideration in remedying something that has been identified as a violation on the basis of race.
Yep.
So just try to wrap your mind around that. So the case is so many things in our world these days, where up is down and down is up, right? Liz Murrell's on one side, one point, then on the other side. The laws need to be implemented because of the Constitution. Now maybe they violate the Constitution. It's just completely insanity. But unfortunately, it seems pretty clear. Number one, the current map in Louisiana, that's gone. That's a foregone conclusion. That map is gone. But it's just a matter of how far the court is going to go.
Yeah.
In further gutting the Voting Rights Act.
So the attorney that was representing, you keep calling them the Robinson interveners, which is confusing for people, but basically it's the attorney that's representing the Black voters.
That's correct.
In the case.
Yes.
They caution that adopting the position that the white voters are taking would throw maps across the country into chaos.
We're talking about that's the position that the federal government and our state government are taking.
What she was pointing out, this attorney, is that if we just got rid of Section 2, then there would be nothing stopping Louisiana and many other states like Louisiana from just redistricting however the hell they wanted to, which could mean that they could, because again, as you pointed out earlier,
partisan gerrymandering
is totally fine.
Yeah.
You can do whatever you want to entrench Republicans into seats. So we could be in a situation in which Louisiana comes back and creates a map in which not only the black vote is completely diluted, but also the Democratic vote is completely diluted. And that could happen in a lot of states across the country in which Republicans have basically full control over redistricting. This is like extraordinarily, this is not just about what's happening in Louisiana. It's going to have ripple effects throughout the country.
There's no doubt. I mean, the C.C. Abrams and Fair Fight did an analysis that they think that it would result in like 15 to 20 Democratic seats, Democratic districts basically being flipped. In other words, making them districts that now like are either safe or like possible for Democrats to obtain that would flip. And I think it's just like, as a person, I was thinking about it last night when I was like very tired and half drunk and had been listening to all this goddamn bullshit with the oral argument that like, it's the thing that it gets to, is the one person, one vote, I mean, that's what we believe is like the imperative of democracy and of our Constitution.
Right.
And the way that the laws go about that are sort of hit or miss. But this is like, we really would be 100% getting away from that, like entirely.
Yeah.
Where like the notion of one person, one vote, like is kind of meaningless. That state legislatures can just like district in whatever way they want.
Yeah.
Without consequence. So if the Supreme Court goes with the most extreme version of this, which is Louisiana's position, which is get rid of Section 2, like it's unconstitutional, get rid of it, then you're right.
Yeah.
With the federal government's like proposal, like the map still has to be like take into account like the reasonable things which can be partisan, can be incumbency protection. There's an outer limit, but like the outer limit is really far. So I just want to be clear about that.
Okay.
Like it's like there's not like what I think the Supreme Court's going to do is go with that. They're going to go with a theory that's like, oh no, like don't worry, which like will gut the Voting Rights Act, but it won't make it so that like they can just do literally any like that just has no the
There's no
only
limit.
logic. But that should give you very little comfort. Very little
God's ears
comfort.
or whatever
But
the hell
yeah,
that statement is.
exactly. Very very little comfort. Yeah.
Okay.
But a little bit.
Is there anything else that you want to say about this case?
No, I think just I think it's probably underappreciated both here and elsewhere, other than like among legal scholars, about like the sort of the enormous impact that this is going to have across the country, both for minority representation in state legislatures, Congress, and for democracy writ large. Like, I don't really think that there's any way to overstate the significance that this case could have, given the new question presented, and given what I think, like, it seems like from oral argument that we're heading down a path of just how bad is it going to be, with how much do they gut one of the very few remaining protections in the Voting Rights Act.
Okay. We're going to talk about Chiles v. Salazar. Okay. So
Another really problematic case.
really problematic. So the background on this is that in 2019, Colorado passed the minor conversion therapy law, which bars mental health professionals, licensed mental health professionals, from providing clients under the age of 18 with conversion therapy. And it has a carve out an exception for religious ministry, which is important, I think. So the case is being brought by a plaintiff named Chiles. She's a Christian licensed counselor. She filed the lawsuit claiming that the law violates her First Amendment right to free speech and to freely exercise her religion. So she's claiming that in her therapy, she's not trying to convert her clients, but she does try to help people that come to her when they have the objective that may include trying to like eliminate unwanted sexual attraction.
To align with their religious theories.
Yeah, exactly. So so she filed this lawsuit, and the state's claim is that its whole purpose for enacting this law is to regulate the healthcare profession and therapist conduct rather than their speech, right? So that is the core issue.
It's whether this is about regulating speech or whether the law is about regulating speech or regulating conduct.
That's right.
Because those two issues are subject to different levels of scrutiny.
So the state's saying that the conversion therapy, as you know, they've defined it's harmful, it's a discredited practice, and that they're trying
There's a lot of research on it.
Yeah, and they're trying to protect minors, right? And that this is a completely permissible regulation of the practice of medicine/therapy.
Yes.
Okay.
Even though that therapy only involves speech.
That's right. So the issue that is before the Supreme Court is whether a law that censors certain conversations between counselors and their clients based on the viewpoints expressed regulates conduct or violates free speech, which is a violation of the First Amendment.
Which I'll say before you get into it that the fact that, like many cases, the fact that the Supreme Court took this case is concerning. Because both the district court and the Eighth Circuit are pretty squarely in line with federal court precedent that, yes, differentiate between conduct that incidentally involves speech versus state action that regulates speech. So I thought that like those decisions were like very well reasoned and like squarely within current precedent. So the Supreme Court taking it up is like concerning.
Yeah. Well, and I think that to me, it seems like, as with Mahmoud, which we had talked about, it's just the Supreme Court is kind of anything that has anything to do with religion and religious opposition to gay rights, essentially, they're going to take up because they want to
think about it a little bit more.
Yeah. They're mostly concerned with any sort of regulation on religious people being able to discriminate against gay people or like introduce the idea that gay people and trans people exist. They have a problem with that. So this case, let's just not be Pollyannish about this. This is in line with that kind of thinking on the Supreme Court as I see it. So the fundamental issue to me to kind of start this with is standing. So this therapist, she's licensed and she's not even really claiming that she is doing conversion therapy.
No, she's claiming the opposite. She's saying that like that she has no intention of doing conversion therapy, but that she would like to talk about things with people that she claims might somehow be implicated by the law, like that they're uncomfortable with their own sexuality because they believe that it conflicts with their religious principles. So yes, under like traditional theory, which the lower courts also did find that she had standing, but like you and I have already talked about this. I mean, like that's a really valid question here. If you're saying that like, what I'm going to do is not going to violate the law, but maybe it's like sort of in the realm of what the law says is like I can't do, and so then maybe I could then be subjected to some sort of punishment, and also the law's never been enforced against anybody.
Yeah, which is a point that Justice Sotomayor makes.
We have been very clear in Susan B. Anthony that there has to be a sufficiently eminent and credible threat of prosecution. We've said merely having a law on the books is not enough. A chilling effect doesn't exist. This is an unusual case because we have basically 6 years of no enforcement of this law, 3 before this lawsuit, 3 since. And we have the entity charged with administering the law saying we're not going to apply it to your kind of therapy. So how does that fit into being an imminent threat of prosecution? Yes, you have an argument. They've disavowed it. How does that give you standing?
Standing is tricky, as we know. You know, I mean, it seems clear to me that, they wanted to find a sympathetic plaintiff because conversion therapy does have there's so much evidence about how harmful it is that they didn't want a plaintiff that was saying, I want to engage in conversion therapy.
Right.
Although it would be no different with the outcome here, as we'll talk about, in terms of if this law is ruled unconstitutional, it would have that same effect.
Yeah.
I mean, on the flip side, then I guess it's not that dissimilar to our doctors in cases challenging the trigger ban, that I'm not trying to provide an abortion. I'm trying to provide care that's not an abortion. And I think that the state might think that what I am doing qualifies as an abortion.
Yeah.
Just being the devil's advocate, that
No,
standing is tricky.
I know. I mean, I think that that's really important because when I was listening to the oral arguments, a lot of the arguments on the side of Chiles were it's having a chilling effect. It's having, this law has a chilling effect. She's not really sure whether or not the law, maybe it hasn't been applied. It's not being enforced. Maybe it hasn't been enforced against her, but
And
who's to say it might.
Certainly, I have definitely argued in cases that the fact that a state has not enforced a law and the fact that they say they are not going to is insufficient.
Yeah, that's, cold comfort.
Yes, exactly.
So there's a couple of issues in this case that I want to suss out. So the first one is this whole idea of viewpoint versus conduct, right? Okay, so a lot of the conservative justices pressed Colorado on whether this ban is actually regulating speech or conduct. Okay, so speech, what the counselors are saying to their clients versus conduct, which is professional practice.
Yes.
So this is extremely nuanced and difficult, I think, because if you are a therapist, you are providing care, medical care. I mean, you may not be an MD, but even if you're a licensed social worker or a licensed therapist in some respect, Colorado's argument is that we can regulate you because you are seeking a license from the state and you have a duty and to protect your clients. And we have a duty to protect the people of the state from crazy practices that you may engage in.
So to me, that it's both very nuanced and not. Regulating conduct and regulating speech are viewed very differently. So in other words, conduct being the practice of medicine, speech being things that might be associated with or related to the practice of medicine, but are not the practice of medicine or of any profession. Because it's the same thing with lawyers and, with all professionals, that the state has the ability to regulate conduct, even if it's incidental to speech. So that's pretty clear. The problem here is that the conduct is just speech. There is no other conduct.
Yeah.
Yeah. So they want to carve out, though, that is different. The state can regulate conduct if it's speech plus medication. And as you know, this came up with Justice Jackson, questioning them about how would this be different with scrimmage and with, gender affirming care, that oh, well, that's different.
I'm wondering why this regulation at issue here isn't really just the functional equivalent of scrimmage. I mean, I realize that there were 2 different constitutional provisions at issue, but the regulations work in basically the same way, and the question of scrutiny applies in both contexts. So it just seems odd to me that we might have a different result here.
Well, scrimmage was a law that regulated on the basis of age and medical treatment.
No, but here's what I mean, right? In scrimmage, we had a state that wanted to prohibit certain medical treatment, gender-affirming care, being given to minors in the form of medication. And we said that was okay, and I understand there are particulars with respect to how the arguments, the constitutional arguments worked, but the state can prohibit that. Here we have a state that wants to prohibit gender-related medical treatment in the form of talk therapy, but we now have the First Amendment that is inhibiting the state's ability to do that. And I'm just, from a very, very broad perspective, concerned about making sure that we have equivalence with respect to these things.
Well, from a very broad perspective, there shouldn't be equivalence because obviously we have a First Amendment. So when you have
because
treatment
talk
that
therapy,
speech,
the speech is what is at the core for you. It's
Right.
not necessarily the state's interest in protecting minors from what it believes to be certain harmful treatment.
If your conduct is just speech, does that take away the conduct part entirely? If the care that you're providing, the conduct that you're engaged in, is solely speech, have they basically lost their ability to regulate? I don't know where that
Where is the
goes.
line?
I don't know
Yeah.
where that goes.
Yeah.
Yeah.
I mean, one of the things that Justice Jackson points out, she says it would be odd to think two different medical professions could treat the same condition.
Yeah.
So one with talk therapy and one with medication, right?
I guess it seems very odd that you could have two scenarios where you have two licensed professionals both attempting to provide treatment to an individual, say for the same issue, that, you know, the person says, I'd like to live consistently with my biological sex. I feel that I'm not doing that. I'd like your help. Medical professional A treats that quote-unquote condition with medication. Medical professional B treats that condition with talk therapy. And I guess under your theory, those two scenarios are sufficiently different from a constitutional perspective that one could be allowed and the other not.
She's like asking, like, why isn't that inconsistent, you know?
How do we square that?
Yeah.
Yeah.
How do you think about speech-based treatment versus medical treatment, other kinds of medical treatment? And then
a Pandora's box, although they seem poised to go with this theory. The court being, right?
They do. I mean, Alito says, I mean, he's 100% convinced that this law is discrimination, right? She's dealing with clients that have those particular views, and the state is saying, like, no, you can't, like, help a client rationalize or, deal with those views, and that's like blatant viewpoint discrimination.
Right, but the fact that she's engaging in therapy should be the end of the answer, right? The front end, that it's conduct.
Yes. So that's one of these arguments that comes up in this case. And then the other one that came up that I think is really also quite dangerous is this like skepticism about medical consensus. Okay. So in defending this law, they talk a lot about the standards of care, right? And the standards of care right now say that conversion therapy is actually quite harmful to minors, and the state has a compelling interest to protect minors from this care that is harmful. And so that justifies them passing this ban on this, right? Alito, again, like he comes forward with questions about, haven't we dealt with issues where medical consensus changes over time, right? And where do we kind of draw the line? And this seemed to be an argument that really resonated with a lot of the conservative justices. Consensus can change over time. And Alito even points out this, like, you'll tell me what case this is, the forced sterilization cases, like
Bell.
Yeah.
Bell.
Yeah. So like, which was horrible, where the court upheld forced sterilizations based on mental incapacity, or as the court saw it, defections or whatever.
Was there a time when many medical professionals thought that certain people should not be permitted to procreate because they had low IQs?
I mean, one of the things that was interesting to me about this is that, like, Alito's holding up Bell as like, this should be the answer. I don't know that he actually, like, if Bell came before them today, I'm not sure that he would actually strike down that case, Right.
I mean, right. And it's an example of extreme government overreach. It's also, based on bad science. But just like, they seem to be perfectly fine with upholding. Basically, it's getting at the state's the ability to regulate public health.
Yeah.
Which, like, the Supreme Court in federalism theory has given great leeway to the states, that they can regulate health and safety type of things, even if there's not much evidence that supports.
Yeah.
Like, no,
And they
that
just
is the deal.
decided the case in Scrimeti.
But that's all about conduct stuff.
Yeah.
In this context, I'm kind of like, what are we talking about? This is about whether this is regulating speech or this is regulating conduct, and this is regulating conduct.
Yeah.
So this is where they get kind of, again, like, outcome determinative. If we put this thing that we care about, being able to provide conversion therapy in that bucket, then, we're pretty much saying that, like, states can do that. So how can we put it in the other bucket where it's just about speech?
So this, like, opens up a whole line of questioning in the oral arguments about, okay, if it's speech, then can we regulate talk therapy at all? There were lots of hypotheticals thrown out. What if a therapist has a client that is suicidal and the therapist is like, I don't know, maybe you should go through with suicide. Like,
or it's like, and actually, like, here's like some, like, I know other patients who have committed suicide, and here's some ideas.
Yeah.
Like, this is what I would recommend.
Yeah. That's all speech.
Yes.
No medicine is being provided. Like, there's no, quote unquote conduct as, like,
if that's how we're defining
it. If that's how we're defining it.
There's no limiting principle if we're defining, like, medical care or licensed care. If we're defining it as shit that involves medication and might be also involve speech, and shit that does not involve medication and only involves talking, there's not a limiting principle then. All the part over here is subject to strict scrutiny. It will be very hard for a state to pass a law. I mean, you could try, regulations that say do no harm kind of thing. That's like the Hippocratic Oath type of thing. Like, that might be viewpoint. Depends. What does that mean? What's the harm?
Yeah, that could be a viewpoint.
Yeah, because, like, promoting conversion therapy, that could be harm. Not doing conversion therapy, that could be harm. If we divorce talking that is in the context of what everyone understands to be part of professional care, whether it's medical, it's professional care. It's from a licensed social worker, it's from a licensed psychotherapist.
Right.
It is treatment. And they call it treatment. It's called talk therapy. Call it talk therapy. If you take out the talking part of it, which that's the only part that exists with this treatment, then I don't know what the limiting principle is. Justice Barrett did do some, like, going down that rabbit hole of, like, then how could people be held? Could these people be held accountable under malpractice statutes?
Yeah. If we're treating therapeutic talk or whatever as, like, pure speech.
Yeah. So not therapy, basically.
Yeah.
Yes.
And the states don't have the ability to protect patients from what might be dangerous or deceptive, like, practices, then how do you bring malpractice lawsuits against those therapists, right? These talk therapists. With that rationale, like, Barrett was like, okay, I'm open to this.
Which, granted, it should have been, of course, that line of questioning results in the opposite sort of conclusion, right? Where it's like, how would we regulate this professional practice then? Like, if all speech is fine, then how do we regulate where we clearly need to this professional practice? And instead, she's like, sounds like that we should not, that the state should not be able to regulate this.
Yeah. This should just be a free-for-all.
Yeah, I mean, I'm ready for lawyers then to start bringing, like, all the lawsuits about everything that regulates our conduct / speech. I mean, yeah, what's the difference? If my speech is just speech and not professional conduct, then I don't know why I should be able to ever be sued for malpractice.
Yeah.
But you think that they're going to uphold it? So that you think they're going to strike down the law?
The potential outcomes in this case seem to be that they would just strike down the law completely, which is what they did in Mahmoud, right? Nope, can't do this. Like,
Right.
whatever. Or you're like, yes, you 100% can do this in the case of Scrimeti. That's the worst case scenario. Like a sweeping ruling that like, this is speech. We can't regulate speech. This is a violation of the First Amendment, like full stop, and viewpoint discrimination, right? The best case scenario is that they would say it's likely a violation on viewpoint for sure, maybe speech, maybe free speech. And so strict scrutiny should apply. We're going to send it back to the district court and have them apply strict scrutiny. And then the district court will have to analyze that as to whether there's a super compelling state interest in doing this.
I think that's probably the most likely, is that they say that this is speech, it is not conduct, and therefore it's subject to strict scrutiny. And then it just like opens just a Pandora's box about what does that mean? If that's not conduct, what else is it?
Well, I think that one of the concerns that I had listening to the oral arguments is that like Kagan seemed to be open to the viewpoint discrimination argument here.
Mrs. Kagan?
Do you think if there were the exact opposite kind of law, so this is a therapist that, consistent with the child's goals, is trying to get the child, to accept a gay identity or a trans identity. So it's exactly the same statute, but it's just flipped around. Same argument?
She seemed to be kind of open to the viewpoint discrimination arguments that were being made. I don't think that she would go so far as to be like, throw the whole thing out. But I do think that she might, and I don't necessarily know that she was buying the speech arguments, just the viewpoint discrimination arguments. I think that if they want to get Kagan, then they'll remand. And if they don't care about whether or not they get Kagan, then they're just going to throw the law out.
Which either way, I don't think the result matters going forward, honestly.
Yeah.
I mean, it's just a more reasonable, it's a more reasonable thing for them to do to remand, because that's what's supposed to happen. But again, if they decide that it's this higher test, it's not going to matter very much. But either way, in terms of what's the Pandora's box, I think like there's just going to be a lot of litigation. They claim, of course, to be trying to like get out of the business about having like difficult tests and, encouraging litigation. And
but
like
they're just making it more confusing.
So much more. What like controls for too much litigation is clear precedent.
Yeah.
So when everything's kind of up for grabs, both like literally and just like people are kind of like, I don't know, let's see. Then like, no, there's just like, I mean, why not bring all kinds of litigation? Some of this might be good for us. I mean, like counseling people on abortion options, like abortion referrals, like that is just speech. And that can be in the context of medical treatment. That can be in the not context of medical treatment. But if we're divorcing all of that, then like, I mean, there is no rationale for how that is not viewpoint discrimination that's subject to strict scrutiny.
100%. I was thinking about that when I was digging into this case, was that we have a lot of laws on the books in Louisiana that say you can't counsel or refer people to get an abortion. Well, if that's speech.
Yes. Which it is.
Yeah.
I mean,
so the other outcome that I think we'll be watching in the decision on this case is whether the decision can actually limit broadly the state's power to rely on professional norms, medical consensus, standards of care to protect patients from fucking crazy people.
I think the court will avoid weighing in on that.
Okay.
But because I don't think they need to. They always want to have that both ways. And they just want to like point out where they think the state did it right and where they think the state did it wrong. And and it's easy to say when the state did it wrong when it's like many years after the fact, like with Bell too. You know, like that's like
hindsight is 20/20.
Yeah, like and just like if everyone considers that to be one of the dark days of Supreme Court precedent in terms of like things that the court has sanctioned. We're getting into more of those dark days. So
Yeah. It's the Trumpy Casa of yore.
I think the only other thing to say, which I'm ready to wrap up on, fucking Chiles also, but there's a lot of talk about NIFLA in the context of
Oh my God, yeah.
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 And so just very briefly, NIFLA was the California law that mandated the crisis pregnancy centers like post like what were the posters, what were they mandated to say?
Yeah, so it required they post posters that not only tell people where they can obtain an abortion, but also had some sort of, affirmative statement that the state is supportive of abortion. And then there was also a narrow part of that law that was being challenged that said that the crisis pregnancy centers had to inform people that they did not provide abortions. That I think probably would have been upheld. It was
Just
like
the latter part.
Yeah, like that. I think like California just went too far, honestly, in that
Yeah.
and trying and like forcing the crisis pregnancy centers to, affirmatively say something that they didn't believe, and that the state was compelling them to provide information, speech, whatever, to their clients that was not their viewpoint.
Yeah.
And
Yeah, exactly. NIFLA was like a very frustrating decision because California was like trying to do something to combat the less information coming out of crisis pregnancy centers. And under the theory that, you can't, like false and misleading advertising. But those regulations are subject to rational basis. Like you can't, it's hard to do that. I thought the lower courts in this case did a really good job of differentiating NIFLA from this regulation because NIFLA was really about speech. It was like it was like what you have to post in your clinic as opposed to as a part of the practice, as a part of the care that you're providing, the therapy that you're providing, what can you or can you not say? So like the conduct versus speech part is like very clearly different to me. And while frustrating, I don't think that NIFLA was like wrongly decided under like ordinary Supreme Court precedent.
I think it could have been more narrowly decided. Like
Yeah.
this would have been my preference. My preference would have been for the court, and if they were acting in good faith, this is what they would have done with NIFLA. They would have said, the state requiring the clinics tell people that they don't provide abortions is 100% fine.
Yeah.
The state should be able to do that. And the Supreme Court used to carve out, like they used to be able to, they did this in Callais.
Yes.
Right? Like in Callais in 1992, it was like, and one of those omnibus
those were
abortion
different laws. This is the same.
But what I'm
yes,
saying
I
is
hear
the
you.
principle is the same, is that like, these kind of like regulations that states pass, laws that states pass that like kind of regulates a bunch of different things in different ways. Like the court used to say, okay, this is one thing, this is another.
Absolutely.
Thing, right? And NIFLA, they could have done that.
For sure. So I agree with you on the front end that one of the whole principles, again, also of federalism is supposed to be they're coming up with the most narrowly tailored solution, right? So yes, they're only throwing out the parts that they think are really objectionable, but leaving the parts that aren't. But I don't think that anything about that case puts them in a bind in this case. And that's what the lower courts found as well. Again, being a big distinction between speech and conduct.
Okay.
Certainly the Supreme Court, like, I think might use that as like another circumstance where they have struck down viewpoint sort of discrimination. But like that was speech. That was speech. That was incidental to conduct. This is conduct where the speech is incidental to the conduct. So anyway, that's NIFLA's sort of like in the wings of all of this.
I fucking hate the crisis pregnancy centers.
I know.
So for our listeners, I hate crisis pregnancy centers. We talked about them during the legislative session. We're actually going to do a series at the end of the year on crisis pregnancy centers. We're going to do a deep dive because I hate them so much about how fucked up they are.
But they do need to be more regulated.
And they need to be regulated.
Yes.
And it's all fucked up.
There's no doubt about that.
Summary, it's all fucked up.
And bullshit.
So we had an election in Louisiana. It was like municipal elections, some like local issue stuff, blah, blah, blah. The big things were mayor of New Orleans City Council, and
clerk of court.
clerk of court, like in
Sheriff.
the New Orleans area. So New Orleans is struggling. We have a mayor that we have previously talked about on the podcast who's been indicted. Listen, New Orleans ain't big and it ain't easy.
That is true.
So I don't know why it's called
true.
I don't know why it's called the
true.
Big Easy. It's basically, this is how my daughter described New Orleans one time, which I thought was so cute. And she was like 6 when she said this. She said, New Orleans is like a small town with a big personality.
It's true. That's totally true.
And that, yes, that is 100% true. The mayor of New Orleans matters a lot because we are the blue dot in the Red Sea of Louisiana. And so who our elected officials are locally really, really, really matter as to how much pushback is going to happen at the state level.
Yes.
And so this is why I think we wanted to talk about this a little bit, not just because now it's not just the state level, but it's also at the federal level.
Yes.
Helena Moreno, she was a former state representative and she went on to be a member of the city council.
Currently.
And president of the city council in New Orleans. And she ran for mayor and she ended up getting 55% of the vote, which gave her, the elect status outright. So,
right. No runoff.
Yes. I try to get her on the podcast, so we're not going to spoil everything.
I'm very happy that there's not going to be a runoff. I can tell you that. Like, just very happy. Like, those runoffs are bruising. I'm really happy that this one's in the books.
Yeah. Well, I want to make a note, just to inspire people, is that the unofficial turnout rate in this election was 40%, more than 40%, which is huge considering that like just a couple of years ago for a governor,
it was 25.
Yeah. I mean,
yeah,
like really pathetic. And of the people that voted, almost 40% of them voted early. That's good. I'm just looking at that in terms of how engaged people are, and they're worried about who their elected officials are and they're getting out to vote. And that's a good thing for democracy. There were a lot of different issues in this particular election. Obviously, we do have crime issues. But we also have a lot of other issues like
the
budget. We have issues like infrastructure.
Oh my God.
Our roads are shit. We can't get decent trash pickup. Our roads are flooding all the time because we live below sea level. We have housing issues, massive housing issues. General environmental issues in that beyond just the kind of day-to-day flooding that we deal with in New Orleans. We also have the climate change threat.
And just the corruption that feeds.
Yes, exactly. Like,
the trash contracts, the street.
Yeah, there's been like
repair contract.
Really a lot of issues with transparency and accountability. So I'm hoping it'll be a new day for the city.
We have a very good qualified person who has won. And that's great.
Yes.
New Orleans also passed the Home Rule Amendment that prevents discrimination based on former incarceration status.
Yes.
That passed by like a ton. So we're doing okay.
It's good.
Down here.
It's good.
On people voting and people voting in an informed way.
Yeah. But it's important for people to stay engaged because the governor has now called a special session.
The governor is also, to be clear, he has explicitly requested now that the Guard be deployed to New Orleans, Baton Rouge, and Shreveport, the only Black cities. We should assume it's going to be taken up at some point.
Yeah.
And particularly because Trump is going to be like loving fighting against Helena Moreno,
Oh, yeah.
She's a beautiful beautiful woman who's a Democrat. So he'll love to get in a fight with her.
Yeah, they really hate the like mouthy
Ladies.
Yeah, the mouthy women. They especially hate them if they're women of color.
Sort of obsessed with her too, like he is with any woman who's white that is pretty, but is an opponent of his.
Yes. So we have a special session that Landry, the governor, has called, and they're not supposed to be drawing new maps. I guess, again, waiting for the outcome in Calais, but who the hell knows?
You're just doing other voting bullshit. I didn't even know what's happening. It's on voting. So that sounds bad.
Yeah, on elections.
That's bad.
Yeah, exactly. So they're trying to do some stuff ahead of 2026 to like fuck things up.
I think this is just mostly going to be just trying to disenfranchise people writ large. There's a lot more like voter ID, purging the roll, literacy tests. There were a lot of talk in the Calais oral arguments about how like, no, there's no need to worry. Literacy tests would still be unconstitutional. Maybe. I don't know.
I mean, at this point, I think the literacy tests are favoring Democrats. I'm just going to say, I'm just going to put that out there. Okay. What do the people need to do, Ellie?
The people need to, per the years, be subscribing, writing reviews, rating us, telling their friends, YouTube, Spotify, Apple Podcasts. Send us some stuff. Send us some stuff.
Send us whatever stuff. We'll read it. We'll read it on the podcast. We don't care what it is.
Well, we'll read it, and then maybe we'll read it on.
I'll make Ellie read it, and then she can bitch about it on the podcast for having read stuff.
Do that. So, don't send something long. Let's be clear. Don't send a book like Monica did. Send like a quick comment that I can read, and then either like give my rave reviews or bitch about. You send a book, I'm going to have to find like an assistant to start helping me with this podcast.
Oh my God. All right. So I don't know what we're going to talk about next week, but we'll talk about something.
That's right. And I'll see you then, and we'll see you guys then.
See you next week.
Thanks, everybody.
Seriously is presented by Lift Louisiana, a nonprofit organization advocating for reproductive health rights and justice.